Thanks, Krishna. First of all, very good morning to all of you. I would want to thank Tim and the entire team at Pairs and Aarti for hosting us here this morning. This discussion is sort of building on yesterday's session, I believe, where we had some familiar faces around. And I bring to you the Indian experience of right to information and how that connects with transparency. For the purposes of this presentation, we'll be firstly talking about the socio-political history of the RTI movement in India, how that sort of shaped legislative design initially, how that legislative design informed our enforcement machinery as such. And what we have currently in India is, and our paper calls it as such, is a reactive model, which is request-based. It depends on the initiation of individuals. We'll be coming to that in a minute. We would also be talking about the necessity of proactive disclosures and how we need to reimagine our legislative design, particularly when it relates to right to information in India. And particularly, I would be speaking in the end about how this context is quite relevant to all developments happening with regard to emerging technologies, particularly artificially intelligent systems, right? So yeah, let's move on to some bit of post-independence history first. So India had inherited colonial laws, some of which even continued after independence. And one notable law amongst them was the Official Secrets Act as such. It sort of engendered secrecy within our governance systems. And therefore, access to information was a matter of exception rather than an entitlement. We, of course, had a Bill of Rights. However, right to information was not explicitly recognized. Interestingly, across a lot of jurisdictions, right to information came due to popular political movements. Now, we've had one very popular movement in India as well, and we'll be discussing that. However, the genesis of right to information in India was initially enforced judicially. The first significant steps were taken by the judiciary, and we see then a trickle down towards popular movements, which is quite interesting, the way I see it. So we had two judgments. This is the second of those. There's one which is cited in the paper if you guys would want to see this. This is S.P. Gupta versus Union of India, famously called the second judge's case. And Justice Matthew, in this case, particularly recognized intersectionality between different provisions of our Bill of Rights, which is part 3 of the Constitution of India. I'm talking about provisions like Article 90, which relates to freedom of speech, Article 21, which relates to right to life, and how we cannot exercise those provisions substantively without having access to information. And when I say access to information, I mean qualitative outcomes. I don't mean information simply in terms of numbers. I mean information which can be inferred easily, right? And there are two important things here. So at the very beginning, we had this very generous judgment. I believe some of this is missing because of the projector. So what happened there was that two essential entitlements were recognized as such. One was a government obligation. The government obligation was on a duty on part of the state to actively convey information to citizens. And the second bit of right to information was an entitlement on part of citizens to go to the state and demand information which they otherwise can't access. So those two connotations were expressly recognized as part of this judgment. And this is quite interesting because as we go further, we see how this gets diluted and how the design organically comes up. And so in 1990s, of course, we had the famous movement by MKSS. If you see that photo here, you can also see Aruna. Nikhil, I believe, is also Aruna Roy and Nikhil. They were leading the MKSS movement back in the 1990s. They were, Nikhil will also be part of the India AI Impact Summit. So if some of you can catch hold of him and talk about accountability, please do so. So they started this movement with a tool called Jan Sunwai, which I believe one of my earlier presenters also spoke of in context of M-Narega. Now, MG Narega, that is. Now, Jan Sunwai was used as a mechanism to demand records, which were public in nature. But please bear in mind, at that point of time, right to information did not have any legislative basis. So people would gather in these community gatherings. The reason why I believe MKSS was particularly successful in India had to do with the fact that not only these community gatherings consisted of rural workers, but it also it consisted of people who were professionals, who had prior administrative experience. So in a way, it was sort of a polycentric gathering as such. Aruna, for instance, was an officer from the Indian Administrative Service. Nikhil himself has been a lawyer. He's represented MKSS and a lot of other organizations in courts. So that sort of polycentric outlook really helped in providing qualitative access to information. What I mean by that is that it was not just about getting access to a set of public records, but what they actually mean. Do they actually lead to inference of certain entitlements, which government welfare services provided to these people, which was in fact missing? And those sort of questions. And the fact that that access to information could translate to providing cogent claims for welfare services, which people were otherwise entitled to by virtue of different socioeconomic programs which the government had initiated. That to me was a powerful motivation at that point of time. Initially, we had a bunch of states which enacted legislations at the state level, and the movement gradually mobilized towards a national law. And of course, we had the first one, which was called the Freedom of Information Act. This was in the year 2002. So this act was notified, but it never really came into force. The Freedom of Information Act 2002 had two particular problems. All the rights there were descriptive in nature, and they lacked the necessary enforcement machinery. And secondly, of course, the problem of exemptions was there. The problem of there were exemptions which were very, very widely drafted. And secondly, appellate mechanisms in particular were missing. And therefore, this law, as I like to call it, was in fact an administrator's delight. And that was the reason why, despite its notification, it never came into force, because there was popular discontent and people sort of wanted a different kind of law. And that's when the deliberations towards the RTI Act of 2005, which is now currently in force in India, began. And when we talk about the 2005 legislation, I would like to call it a compromise. It was a compromise between a demand-driven request from the grassroots who wanted informational access. But at the same time, there was a lot of bureaucratic resistance as well when it comes to right to information. Having to publish documents mandatorily as a matter of administrative routine was something which the government was not particularly comfortable with. And if that was to be recognized as a legal obligation, a lot of people within power certainly experienced problems, and they had problems with that idea. And we see this compromise within the legislative design of Right to Information Act, where individuals are allowed to make requests and initiate informational access. But at the same time, there's an asymmetry in terms of correlative duties which the government had. And I would like to point out and go back to the SP Gupta judgment, which sort of wanted to balance both these imperatives, which is the duty of the government and also the right to access on part of individuals. So those sort of were balanced, but we gradually see that this balance tilts. And of course, we also spoke about how this has been diluted with further amendments and all of those things as well. When it comes to reactive models, for purposes of our paper, we've presented three characteristics which are to be probed. The first is individualization. The second is record centricity. And the third is enforcement through adjudication. When we talk about individualization of rights, right to information does not necessarily guarantee, by virtue of the enforcement mechanism that it lays down, a community right as such. What it requires is individuals to go and initiate requests case by case to public information officers and access particular fragments of information. So therefore, to segregate individual and community claims to information is something which we see as a problem. Secondly, at the time of its framing, governance was largely document-centric, which means that the problem was of access to information which was already put in records. I'll speak a little later when we come to a bit about artificial intelligence systems. But the problem therein is that we do not only currently look out for information which is presented, but technology also organizes this information by virtue of recommender systems, algorithms, so on and so forth. And that creates a problem of informational access and opacity, which reactive models particularly can't deal with. The third problem here, which I talk about, is concerning adjudicatory mechanisms. From the very first instance, when a person goes on to a public authority, be it an administrative department, the mechanism is adversarial in nature, in the sense that you need to put out a request, and that request has to be adjudicated. And of course, in terms of framing, there are different levels to it. For instance, you would first go to the public information officer. If your request does not get guaranteed there, you would move on to the appellate authority. If you're not happy there, you would probably move on to the respective commission. It could be the State Information Commission or the Central Information Commission, depending upon the organization you're going with. And later come the courts, the constitutional courts, if at all you are not happy with the outcome then. So it has created these multiple layers of adversarial mechanisms which require a lot of individual initiation on part of people. And we believe that these are problems which a proactive model could solve for. And yeah, so this was my bit about the positives and negatives, which I've already spoken of. Now, coming to our model of proactive disclosures, we believe that a proactive model must essentially have certain characteristics. Firstly, we should talk about democratic participation. We believe that access to information must necessarily not be based on initiation, because that is a negative connotation. That basically engenders liberty as a negative connotation. That is, it requires individuals to take action. We should rather make the state responsible for providing essential information in mandated forms so that people can access it and have qualitative outcomes. The second bit is, of course, about administrative efficiency. We will be later in my presentation talking about systems theory, particularly Simon Deacon's work on that. But what we believe is that legislative design and having an adversarial mechanisms in terms of an independent body, be it courts or commissions for that matter, is not enough. What you require really is to build administrative routines that are integrated with legislative intention. And that is a problem which I believe currently we're facing in India. Within our paper, if you look at it, there's a footnote where we cite SNS. It is Satar Nagarik Sansthan, which did a survey. It was quantitative in nature. And they basically release a survey on the state of RTI every year. And what they found out was that if the state was to actively disclose essential information, which by the way, it is mandated to do by virtue of Section 4 of the RTI Act. But the problem is that the enforcement machinery for a proactive model is missing. 70% of the requests which currently happen would actually not have to be initiated in the first place. So the problem is of ensuring that routine disclosures are integrated with administrative routines, and which requires us to rework our legislative design. This was my bit about the enforcement machinery under the RTI Act. If you talk about the Act particularly, I spoke about the nearly 5-tier system, which is quite elaborate and which we already have. The problem of initiating a request yourself, the problem of using your own resources in an adversarial system means that the extent to which a right is enjoyed becomes subjective. It is not all pervasive. It depends on the kind of resources one enjoys. It might depend on the kind of time one wishes to give to particular purposes. And therefore, a right within itself stops becoming a legal entitlement as we should have it, right? And my recommendation is that a change in enforcement machinery is the first bit. When I spoke about the RTI Act and its legislative design and such, we have Section 3 firstly. Section 3 mandates a very broad right to information. However, when we go further, we see that there are two different mechanisms of enforcement. First is the adversarial, which has this elaborate enforcement machinery in terms of your Central Information Commission, the State Information Commission, public information officers. But all of them depend on the individual to go and tap the state to seek information. On the other side, you have Section 4 of the Right to Information Act. Within Section 4, the unfortunate problem is that there's no machinery independent as such. Even the existing machinery for purposes of enforcement of all the other entitlements is adversarial. So although Section 4 under the RTI Act particularly prescribed that states should make active disclosures, and there's a huge laundry list of it if you go to the legislation. The problem is that, in fact, it is not enforced. And therefore, we had this case concerning, this was a 2023 Supreme Court judgment. It concerned an advocate who petitioned the court, Kishan Chand versus Union of India. So Kishan Chand was a lawyer who brought this problem as a matter of public interest litigation to the court and said that how Section 4 cannot be enforced. Also, a bit of legal background to this. We had a judgment before this concerning the Information Commission and the state of Manipur, wherein the court explicitly had stated that obligations under Section 4 are not legally enforceable. They are basically prescriptive in nature. They are not a matter of hard law which can be enforced as such. And that, to me, created a lot of problems, which this judgment sought for through interpretive flexibility. The judgment prescribed a different model. It said that disclosures, proactive disclosures, must necessarily be read in tandem with Part 3 of the Constitution, just like the S.P. Gupta versus Union of India judgment. But then again, the problem with judicial enforcement as such is that courts are not suited to deal with problems which are polycentric in nature. Now, what do I mean by polycentric problems? I believe when we are solving for a problem like transparency, it is not necessarily a legal problem as such. It has multiple strands. For instance, one bit of that concerns lawyers and judges. The other bit of that concerns governance machinery. Then we also have technologists who are now important because we use a lot of data sets and they are used for automated decision making as such. And all of these brought in together sort of create one large complex. And this cannot be solved for by a reactive model, which depends on adversarial mechanisms as such. And my contention here is that this is where participatory approaches help. We require a whole of society community orientation when it comes to solving for problems like transparency. I would want to talk a bit more about systems theory, and later now I move on to AI. When we talk about systems theory, and this is the work of Simon Deacon particularly, he's a professor at Cambridge. Simon sort of says that when it comes to legal systems, they do not only co-evolve with legislative design. They require anchoring political conditions, administrative routines, the societal norms that prevail at that time, which basically means that we cannot have one singular dependency on laws. We require community orientation. We require wider participation. And where system theory works for our purposes here is when we pitch through our paper proactive model. A proactive model of disclosure only works when institutions such as information commissions, administrative departments, which hold PIOs or public information officers, are adept not only in governance, but they are members from civil society They are members from other communities, be it the legal community as such, be it technologists, be it academicians, so on and so forth. The reason is that it is only then problems such as transparency can be solved. We are actually, when we look at transparency now in context of AI, I would now want to move on to the problem that information design has here. When we were talking about information in the pre-agentic AI age, we were only talking about how access to information was a problem. Information was fragmented. It was already there in documents. But how the entire AI lifecycle, right from data sets, models, applications to output, the complexity that they add as such is that they not only use data sets, they use it to design and organize information. For instance, if anybody here has used Facebook, Facebook uses what is known as the collaborative filter algorithm to decide who gets what kind of recommendations. A collaborative filter algorithm works on the principle of similar users are pitched similar kinds of information. So in context of AI particularly, this means that information is organized as per the choices one takes. So I can see Tim is already here.
Session starts in about 5 minutes.
Right. Yeah, thanks. So in conclusion, a reactive model does not work particularly in the age of AI for two reasons. First, it works, a reactive model works on presumption of an adversarial mechanism, which is no longer relevant. The second bit which I have to add is guarding for bias. When we talk about bias and detection of bias in the age of AI, individual case-to-case results are not enough. What we require is a much larger macroscopic view of outcomes. For instance, when we talk about protected characteristics like caste, religion, and other things, it is not just one particular decision which can lead us to infer that there is bias in a system or a data set. It requires us to review a whole set of decisions and see the kind of demographic it particularly impacts. I think this is where I stop. Thank you so much. If there are any questions, please let me know.